Hello dear students, today we are going to discuss effects of adoption. The scheme of discussion will be as under. We will start with the introduction, then we will move on to adoptions under ancient Hindu law, that is the doctrine of relation back, then effects of adoption under modern Hindu law, judicial interpretations on effects of adoption, followed by conclusion. To start with the introduction. Dear students, in the previous lecture on adoption, we understood the adoption law which covered all the religions generally. In this present lecture, we will primarily discuss Hindu adoptions. It is pretty evident from the preamble of the Hindu Adoption and Maintenance Act of 1956 that it is not just to amend but also to codify the law relating to adoption and maintenance for Hindus in India. As a rule, the court is not at liberty to go outside the law, so it was created simply because before the enactment, other customary laws were prevailing and there was no uniformity in Hindu adoptions. There were many customs and disparities in those prevalent usages. In Indian culture, the idea that the son is the only eligible heir to the family makes adoption very appealing. A male child was considered necessary for the future of the family and passing on of land as the family heir according to the traditional Hindu law. According to these traditions, couples who do not have any children or who only had girls wanted to adopt sons. In old Hindu law, if a Hindu widow adopted a son, after her husband died, the adoption was considered to have happened on the day her husband died. This meant that the boy who was adopted had the rights to the property of the deceased husband as if he were there a natural son born before his death. He will also be able to take part in the property's division and inheritance. Now, let us understand the adoptions under ancient Hindu law, the doctrine of relation back. Students, the ancient Hindu law provided that a Hindu widow could adopt a son after her husband died. In addition, this son was to be formally seen as adopted on the behalf of the husband who had died. To make things easier, when it came to inheritance, the son was officially adopted on the date of the husband's death. So, the adopted son could be called the deceased legal heir, which meant he could inherit all the property the deceased owned before he died. The most unusual rule in this theory was that if the deceased's property were given to his brothers or other co-partners, the adopted son would have to return it to the biological father. In this case, the adopted son was thought of as the dead person's son. This custom was called the doctrine of relation back. It is a principle of Hindu law that says some acts have consequences in the past. The main idea behind it is that an action that happened later, adoption in this case, is considered to have occurred earlier. By doing this, a formal fiction is made which gives the adopted person certain rights and duties as if they were in place before the adoption. Even though it went against the notion that property rights can't be taken away once given, the doctrine was based on keeping the adopted father's lineage alive. However, there were two exceptions to the rule. Let's understand them. Number one, the adopted son had to follow through with any legal transfers made by female child after the death of the adoptive father, but before the date of adoption. And second, if the property was given as a gift to a collateral, the adoption could not take away the property from the heir as a collateral. The case of Srinivas Krishna Rao Kango versus Narayan Devji Kango 1955 upheld the idea that an adopted son of a deceased should be treated as his son after death. To explain this doctrine in more detail, let's look at this example. A lady A, a married man B, who passed away in 1920. A, who is married to B and has a limited stake in his property, has no right to inherit it. Based on the rule of survivorship, B's property is split between his two brothers X and Y. In 1930, though A adopted a boy named C. According to the doctrine of relation back, C will be considered to have been adopted in 1920, making them B's rightful heir. Therefore, according to the theory, the 10-year gap between B's death and C's adoption is filled, allowing C to take property from X and Y. It is also important to remember that it doesn't matter what age the adopted child is. The rule would still be valid if the adopted son were born after the husband died. Let us understand this from the text and interpretation mentioned in Mullah's Hindu law. I quote, "The rights of the adopted son, armed as he is with the theory of relation back, have to be effectuated retrospectively. The guidelines wherefore are available in the decided cases. It is no doubt true that when a member of a joint family governed by Mitakshara law dies and the widow validly adopts a son to him, a coparcenary interest in the joint property is immediately created by the adoption coextensive with that which the deceased copartner had, and it vests at once in the adopted son. Furthermore, the rights of an adopted son arise for the first time upon his adoption. He may, by virtue of his rights as adopted son, divest other persons in whom the property vested after the death of adoptive father. Still, all lawful alienations made by the previous holder would be binding on him. His right to impeach previous alienations would depend upon the capacity of the holder who made the alienation as well as on the nature of action of the alienation. When the holder was a male with an unfettered right of transfer, for example, the last surviving member of a joint family, the adopted son could not impeach the transfer. In case of females who had restricted rights of transfer, even apart from any adoption, the transfers would be valid only when they were supported by a legal necessity. An adopted son is bound by alienations made by his adoptive father before the adoption to the same extent as a natural born son would be." Unquote. Now, let us understand the effects of adoption under modern Hindu law. Students, this situation, as discussed above, and various caste restrictions on adoption and capacity to adopt led to the creation of Hindu Adoptions and Maintenance Act of 1956. The doctrine of relation back was done away with when the Hindu Adoption and Maintenance Act of 1956 was passed. Now, according to the third exception to section 12 of the Act, the adopted child only becomes a son or daughter from their date of adoption. In its basic form, the doctrine of relation back does not apply anymore, but it is still essential in some ways. The adoption process creates a formal connection between an adopted child and widow's late husband. The widow's late husband then becomes the adoptive father of the child. The Hindu Adoption and Maintenance Act of 1956 replaced common Hindu law and made adoption law more transparent. One of the main goals of this act is to eliminate differences between castes in Hindu culture. Under customary Hindu law, adoption could only occur between people of the same caste. However, the Hindu Adoptions Act could get rid of this limit. There is no clear rule in the Act that says that adoption can only happen in the community. However, some problems with the adoption law haven't been solved yet, and the courts haven't come up with any binding legal rules for them. Effects of adoption. How well Section 12 of the Act works. An adopted child shall be deemed to be the child of his or her adoptive father or mother for all purposes with effect from the date of adoption, and on such date all the ties of the child in the family of his or her birth shall be deemed to be severed and replaced by those created by the adoption in the adoptive family, provided that the child cannot marry any person whom he or she could not have married if she or he had continued in the family of his or her birth. Any property which vested in the adopted child before the adoption shall continue to vest in such person subject to obligations, if any, attaching to the ownership of such property, including the obligation to maintain relatives in the family of his or her birth. Part C. The adoption shall not divest any person of any estate which vested in him or her before the adoption, and this one is very important. Section 12 discusses what happens following a valid adoption. When a child is adopted, they are transferred from their birth family to a foster family. Following the adoption, the child will have no contact with the birth family. From that moment on, they will be regarded as the natural children of the adopted family. The proviso states that this clause is open to 3 exceptions. First, the adopted child cannot marry someone he would not have married if he had stayed with his biological family. This proviso states that incestuous relationships between relatives are not permitted, and that an adopted child cannot lose any property that was given to them when they lived with their natural family before adoption, as long as they continue to meet the obligations associated with that property. Furthermore, the adopted child is not permitted to take away from anyone in their adoptive family any property granted to them before becoming an adult. As clause B and C demonstrate, adoption is prospective, which means that the natural decline that occurred before adoption cannot happen again after adoption. Moving on, codifying the old Hindu law that looked at the doctrine of relationship back is the primary goal of this section. The Act gets rid of the idea of relation back and gives the adopted child the same rights as a natural born child in the adoptive family from the date of adoption. The effects of adoption are all the legal things that happen after a child is adopted. In Section 12 of the Hindu Adoptions and Maintenance Act, it says exactly what happens after someone is adopted. The wording in this part is very clear, direct and strong. It says that the adopted child is considered to be the child of adoptive father for all the purposes, and all ties between the child and his or her original family are considered to be broken and replaced by those with the adoptive family. The fact that the word all is used over and over again with the words purposes and ties is important. Ties is a very broad word that could mean any kind of connection between an adopted child and his biological family, whether it is social, religious, cultural or something else. According to the rules of the section, all of his relationships are changed with those with his adoptive family. Now students, let us have a look on the judicial interpretations on the effects of adoption. Let us consider the decision of A.S. Selja versus Principal, Kurnool Medical College, 1985. A.S. Selja was the daughter of A.S. Radhakrishna. She tried to get into medical school by mentioning that Radhakrishna was her father. She could not secure admission on account of her low marks. Later, she wrote the name B. Shivaramaiah, that is OBC, as she claimed to have been adopted by a shepherd named B. Shivaramaiah. The High Court said that Article 15, Subclause 4 of the Indian Constitution protects people from discrimination. This includes people from the backward classes. To become a member of the backward class, a person must be socially and educationally backward in that group. It was up to the commission or body set up by Article 340 of the Constitution to decide if the person was socially or educationally poor. Because the petitioner was adopted into the backward class, the court said that under Article 15, she could not get into the medical college. It was decided that the petitioner, who became a member of the backward class by adoption, could not get into the medical college under Article 15 Subclause 4 because she had not been through any of the hardships or sufferings that members of the homogeneous backward class go through. The bench stated that the adopted son would not transfer ownership of the property to any individual who had been granted the ownership by the adoption as well. In another case of Saheb Reddy versus Sharanappa 2016, the Supreme Court reaffirmed the legal stance that an adopted child is prohibited from disposing of assets formerly owned by the adoptive parent. The court also determined that the plaintiff would get only the assets of his mother and 3 sisters, but also a portion of the assets belonging to his deceased grandmother. The court reaffirmed that the adopted son, referred to as defendant number 1, would not transfer ownership of the property to any individual who had been granted ownership prior to the adoption. The deceased's wife acquired full ownership of a 1/4 portion, while the plaintiff's mother also acquired a 1/4 share of the deceased's property. An error was made by the High Court in its decision to overturn the decree of the lower court. Let's see in the decision of K. Shantakumar versus State of Mysore 1969, the court held that a boy from a forward caste who is adopted by a backward class citizen does not qualify for reservation under 15 subclause 4. In Kasabai Tukaram Karwar versus Niruvati deceased, represented by the Legal Heirs 2022, the case involves the division of assets among a deceased father's stepsisters and adopted son. It was held that the adopted son would own the property, relinquishing plaintiff's right. The case also contested the relevance of doctrine of reciprocity. The Supreme Court ruled that the doctrine of relation back grants a retrospective nature to sonship, assuming the role of exclusive co-partner. The court ruled that the adopted girl was not an heir and that a child adopted by a deceased official's widow cannot claim a family pension. The Supreme Court has ruled that a child adopted by a widow of a government servant after the death of the government servant cannot be considered part of the family as defined in Rule 54 subclause 14 Part B of the Central Civil Services Pension Rules. The court ruled that the adopted child is considered a member of the deceased husband's family and The rights of a son adopted by a Hindu widow are specifically determined in relation to his adoptive family. The case highlights the legal capacity of a widow to adopt a son or daughter even without explicit instructions from her deceased husband. Students, the next problem is just as important. The right of the people from scheduled castes to adopt a child born in a higher community. Many state governments offer special incentives and prizes for people who marry someone from a different caste. Efforts to bring people together, whether through marriage or adoption, should be supported. If real adoptions happen both ways, they might finally lead to the social equality that the Constitution wants to see. Now, let us discuss the decision of Savanram versus Kalavanti, 1967. A widow whose husband had passed away before the implementation of Hindu Adoptions and Maintenance Act of 1956 took in respondent number 2 following the Act's enforcement. Upon the husband's demise, he possessed both a parcel of land and a residential property. Respondent number 2, Deep Chand, was adopted by Shrimati Bhagwani, a widow, who is the son of Brahmanand and his wife Shrimati Kalavanti. She executed a deed of adoption. Following the demise of the widow, the appellant, who is the closest reversioner of her deceased husband, initiated legal proceedings to contest the adoption. Savanram, who asserted his status as the closest heir to Ramji Das, the spouse of Shrimati Bhagwani, filed a lawsuit seeking ownership of the land bestowed upon him by Shrimati. It was decided that when a widow adopts a son, the adopted son is considered a part of the deceased husband's family. He forfeits all his entitlements within his biological family, and these entitlements are substituted by the entitlements established through adoption inside the adoptive family. Students, Section 12 of the Act explicitly states that when a Hindu female who is married adopts a child, the adopted son will also be considered the adopted son of her husband. The appeal has been dismissed. In the case of a widow, a child who is adopted will be considered the adopted son of her late spouse. Coming to the conclusion, it can be safely appended that despite the fact that with the modification of old Hindu law as the Hindu Adoption and Maintenance Act of 1956, the doctrine of relation back has been abolished. However, the presence of the word by or to a Hindu in Section 5 of the Hindu Adoption and Maintenance Act and the aforementioned decision in Savanram versus Kalavanti case keep that legal fiction alive. Students, the reason for adoption doesn't matter if it is valid and real. The strong use of word or in Section 12 of the Hindu Adoption and Maintenance Act when talking about purposes and ties is important. The effect of adoption on future generations, like how long children, grandchildren and great-grandchildren have to wait to join the community. The real adoption in both the direction would strengthen. That being said, the question that needs to be answered is whether Section 12 of the Hindu Adoptions and Maintenance Act needs to be referred to as such, or if it needs to be changed so that the career planners aren't allowed. The proviso to Section 12, which doesn't say anything about race or class and only talks about marriage and giving or taking away the property from the adoptee, needs more clarification. The basic rationale behind the modern adoption law is to bring people together in such a way that there are no longer any disparities between them based on caste, creed, class or any other offensive lines. With this, we come to an end of today's lecture. Thank you very much. Have a nice day.